It is a busy day in the UK courts today. April 8th kicked off the 2-day hearing in the appeal court in London over Prince Harry's RAVEC case. I wrote about this extensively over on my blog. Here's the gist. Back in February of 2020, RAVEC, which stands for the Royal and VIP Executive Committee, decided to pull Prince Harry's royal security. Recall this was during a transitional period where they were leaving the UK. One of the arguments was that they were no longer working royals, which kind of made me think, is that the reason that it was pushed so hard that they would no longer be working royals, so that there could be this excuse to remove that level of security? Because as Prince Harry has argued, removing working doesn't change the threat level against him, his wife, and his children. Harry brought this to court, and the court sided with RAVEC. The Duke of Sussex appealed this, and his first appeal was denied. This appeal they are hearing. One of the grounds is on this legal principle of open justice, which, not a lawyer, my understanding is that it's a way to be transparent with the public so they can observe the legal process and understand how justice was administered. One of Prince Harry's problems with RAVEC's decision, besides the fact that they didn't do a normal risk assessment, which they typically do, they said they didn't need to because this was a unique case. Okay. One of his issues is that this guy was one of the people making the decisions on his security. If you don't recognize him right away, this is Sir Edward Young. He was Queen Elizabeth II's private secretary. He has shouldered some blame in some corners for Meghan's rough transition into the British royal family. And he was also one of the architects of the Sandringham Agreement. So I could see the way in which Harry would see this as retribution and an attempt to get the couple to change their mind and stay in the UK. I would be remiss if I didn't bring up the Pizza Express loving, non-sweating dancer Prince Andrew, who, despite not being a working royal since 2019 because he lost that privilege, still had his royal security covered by RAVEC, decided after their 2020 decision on Prince Harry that Prince Andrew was still entitled to round-the-clock security, which according to reports was between £2 to £3 million a year, which comes from the taxpayer. While some have argued that the people of the UK shouldn't be paying for Harry and Meghan's security, Harry was offering to pay those costs when he was in the UK. Anyway, I have much more on my Substack. And then there's Dan Wootton, who's back in the news. A former employee has accused him of exchanging sexual messages while pretending to be a woman named Maria Joseph. Now, if you're like, isn't this old news? Haven't I heard this before? Yeah, you have, because it's alleged to have happened quite a bit. In fact, representatives for Wootton have tried to argue this. They wrote that the Metropolitan Police and Police Scotland have investigated Wootton over this allegation, and they decided to take no further action. What the justice for the claimant has argued is that as far as he's aware, these investigations did not relate to the claimant's complaint, but to other allegations. The reason Wootton's lawyers were in court on Tuesday at all, quote, concerned an application by Wootton's lawyers to set aside the anonymity order granted earlier this year to protect the identity of the claimant. I mean, it's not hard to see why Wootton's lawyers would want this, because if the name is out there, Wootton has a platform to discuss this person. And this man who has claimed psychological distress over what happened can further that distress from a lack of anonymity. The judge did rule that the order would stay in place. What the claimant's lawyer had to say is, quote, although the alleged abuse my client has suffered does not afford him the automatic right to anonymity that is granted to victims of sexual assaults, we have successfully argued today that the anonymity order should stay in place to prevent compounding and aggravating the very matters that give rise to my client's claim. If you want to know more about the Dan Wootton, Martin Branning, Maria Joseph, which are all alleged aliases that Wootton allegedly used to exploit colleagues and extract sensitive images, video, to presumably further his career. That's on top of the alleged cash for leaks scandal. If you want to hear more about that, it is under the same playlist where you are watching this video. And for updates on Prince Harry's RAVEC hearing, sign up for my Substack. The link is in the bio. It's free. More to come.